Yes, Mr. Tuck.
May I take my lords, please, to page 214 of the main bundle. So this, of course, is the transcript of the hearing before Judge Willans, which we haven't alighted on yet in this appeal. But this passage in which casts some light, we say, on the way in which the judgment should be read. One sees at the bottom of that page Mr. Archer responding to the judge, acknowledging a point about which, in relation to the question, does there come a stage in terms of age when an allegation ceases to be relevant, the point's accepted, but Mr. Archer goes on to make submissions.
Just tell us at what point in the case this passage is happening.
This is happening during the local authorities' submissions, which were the first submissions, in relation to the Oxfordshire question.
This is the hearing which led to the judge's decision under appeal.
Yes. I'm sorry, yes.
I think it's a pretty long transcript, it's about 60 pages.
Yes. I won't take my lords through all of it.
No, and broadly speaking, there are substantial submissions by each of the three parties about the issue with which we're concerned.
Yes.
And then there's quite a lot of surrounding discussion about case management, about when interim placement decisions need to be made and so forth.
Indeed.
So probably, from recollection, maybe about half of it is to do with or two-thirds to do with the issues in this appeal.
Yes.
And the rest is to do with a variety of case management issues.
Indeed. And the approach taken by the judge is very much to engage with each of the counsel, exploring the questions and testing out various theories and hypotheses. Page 215 is the passage I want to pick up on, please. The second full paragraph, Mr. Archer said, it's the local authorities case, as I've set out in the evidential references document, that this was an impulsive act in the moment. The evidence, we say, is there within these proceedings, within a recent assessment, at times this mother has difficulties in managing impulses. Judge Willans then responds to those submissions and says that he isn't going to engage in a mini-trial, and of course that picks up on the dictum of one of the cases we've got in front of us, but that he did say at the beginning he might be talking in terms of what-ifs. And he says there, taking the authorities case at its highest, and then he goes on to talk about this looking like a case of temporary loss of control, which of course picks up on Mr. Archer's use of the words impulsive act in the moment. And Mr. Archer responded, I'd refine that slightly, my lord, respectfully, and say, in a moment of madness, given the vulnerabilities which this mother has, Ms. Grief took issue with the wording of that. But that then, first of all, sets out what we say is why the judge then in due course goes on to talk about taking the authorities case at its highest. It seems clear that the judgment, which I'll take my lords to in a moment, was asking the question, assuming the authorities case is made out, and assuming it's made out at the highest point that the authority puts its case to me, which is established here as being loss of control, then how would the answer to that question, if I litigated it, be relevant to the welfare disposal in the case?
So the local authorities case at its highest was that the mother had been responsible for the child's death through shaking in a momentary loss of control.
Well, yes. And that
on
was,
impulse.
Yes, that was explicitly explored here. And looking at the bottom of page 216, the judge goes back to the point, the circumstances which are less clear, but likely to be associated with some level of loss of control, temporarily, that a 16-year-old child did a certain act, and we're now considering a 23-year-old adult.
Well, was there any evidence either way about, and I don't want to dwell on this unnecessarily, but was there any evidence about loss of control as opposed to deliberate act, or was this just a concession made by the local authority that it could put it no higher than it being a momentary loss of control?
Well, the latter, but I'm not sure it was even a concession, because, as you've seen, it was volunteered by Mr. Archer in opening the case to the judge.
But it's kind of I don't want to go into the detail of this, but there was considerable body of medical evidence, which included the fact that there were no external injuries.
Yes.
There was also, while we're on this point, that one of the issues that led to a lot of discussion between the experts was that one of the features of the triad, as
Indeed.
it's so called, was not found in this case.
Yes.
So in this case, to do with subdural hemorrhaging, was not found. So that was the picture in relation to the medical evidence.
Yes, there was internal bleeding, but not subdural. Is that right?
Well, there's ischemia, which could have.
There was encephalopathy and ischemia and retinals.
Yes, a unilateral retinal.
Unilateral.
Absence of subdural bleeding, and question whether the foci of brain damage were ischemic in nature or traumatic in nature. But the initial reports of some of the experts had absent the third part of the triad, and given the possible explanations, other explanations for these injuries, they talked about the range of differential diagnoses being that much wider without all of the components, and that was why then there was some equivocation to start with. And then a further complicating feature is it seems to be Professor Mangham's evidence, which then caused the equivocating experts to become less equivocal.
Just going back to the point that I interrupted you on, to do with how the local authority put its case in relation to the nature of any assault.
Yes,
It was a feature of the case that the child had no external injury.
yes, well, yes. So no fractures, no external injuries.
Bruising.
No bruising, no scalp swelling. So in terms of the standard shaking
No
impact,
evidence of impact.
no, the highest was that the absence of scalp swelling wouldn't then be inconsistent with impact against a yielding surface,
No evidence of
but no positive evidence. Which is why it isn't a straightforward case. It's why, if it is to be litigated, it's not going to be particularly on the basis I would have thought that Mr. Bagchi suggested that the mother's team would accept that this is an inflicted injury, because there's an awful lot about it that takes it out of the norm, and not least then the complicating factor of Professor Mangham's subsequent departure from the field of experts prepared to give evidence in these cases after the judgment before of Mr. Justice Keane. Yes, on that slight tangent, that's where the medical evidence was. And my lord, there's no direct evidence of loss of control or anything else, because, of course, as you've seen from the inquest transcript, the mother says she came upon the child already in a state of collapse.
So if the case proceeds as the judge envisaged that it should, with no order for a fact-finding hearing, does all that have to be conducted on the assumption that nothing must be said or found about what happened to the elder child?
Well, I'm not sure nothing could be said or nothing could be found about it. But if I may come to that when I deal with the risk assessment.
Well, it's on my mind, Mr. Tyler, so perhaps you could tell me. If the answer is yes, the supposed events of 2018 have to be ignored entirely, then please say so.
Well, they couldn't be ignored entirely. They're part of the factual makeup of the case. They're part of why we're here. They're part of why the mother is how she is now. What would be impermissible would be to rely on a suspicion or quasi-finding that she was responsible for injuries as founding the basis of ongoing risk. But as we'll demonstrate presently, and as the judge considered clearly from his judgment, the absence of the ability to rely on that collapse as evidence of risk in the mother in no way impedes the proper assessment of such risk, if any, as she poses today.
But if they can't be taken into account the way you said, but can't be ignored altogether, in what way are they to be taken into account?
Well, not as probative of any ongoing risk in the mother, but clearly as part of the background to the case.
Are they relevant to the decision the judge is going to do, these decisions the assessors and the judge are going to have to take?
Only in a secondary sense, if, for example, those events, whatever they were, but we know what the consequence was, explain the mother's presentation, explain the PTSD, explain anything else. explain attitudes to authority, but not relevant.
So causative of the mother's condition,
Yes, but
the
not
mother's circumstances, rather than the mother's circumstances being the cause of the...
indeed.
But in terms of risk to the child, it must be ignored entirely unless there's a 10-day fact-finding hearing next year.
Yes. Finishing the point I started a moment ago, the bottom of page 216, one sees the judge testing out then how the authority was in fact put in this case. But you're saying the judge asked, there are impulsive behaviours now.
Where are you on 216?
216,
Sorry.
just before Mr. Archer's response. You're saying there are impulsive behaviours now that might be an impulsive response, and therefore we're able to work through the risks that may be associated with further impulsive behaviours if the child remains in her mother's care. And the answer is yes. And then over the page, we see the buzzwords impulsive behaviour then being used again. So we say that if one turns on then to look at the judgment, and in particular the judgment insofar as...
Well, I think, I'm sorry to interrupt you again, but I think one has to read the whole of it, in fairness to Mr. Archer, the whole of what he said. It's not just impulsivity, it's whether in the moment of impulsive behaviour the sort of harm that is inflicted is as serious as occasion to the deceased child.
Yes. Which is the central point that Mr.
That is the nexus that I suggest there is between these two events. Yes, sorry.
Yes. So that's the same point that's then being argued on appeal by Mr. Toomey, which is you have to determine this in order to evaluate risk, which the judge rejected then and which we invite the court and then to uphold as being an appropriate rejection of that argument. The two principal questions from the Oxfordshire checklist then on which the appeal is focused, necessity of the investigation coupled with relevance of potential result to the future care plans, engage fully then with Law Bean's question to me. Having criticised the inclination towards close textual analysis, I'm going to have to take the court back to those offending paragraphs, or unoffending paragraphs in the judgment. But would say this before I do so, in defence of my close textual analysis point. This court, we say, should not be looking to see whether a judgment can be picked apart, whether taking any particular paragraph on its own or two in isolation yields some sort of inconsistency or confusion, but rather stand back, look at the judgment as a whole, and engage.
This was a reserved judgment, wasn't it?
It was, but engage with the question that my Lord Peter Jackson set out in HDH, which is this court will uphold the judgment if the law's been properly applied, if the judge has engaged with the relevant factors, and there's been no, I paraphrase, significant error. So page 272 is where Judge Willans determines those two conjoined questions. We've looked at this paragraph. Over the page is a sentence that's already been read out, but we say perhaps in error misunderstood. A finding which would or be likely to identify an existing and continuing risk of a material significant nature, and which without fact-finding determination could not be properly brought into the process of risk assessment, will in my assessment almost always require adjudication by way of fact-finding hearing. Mr. Toomey agreed with that, we agree with that, but we say that the relevant part of that is determining what is meant by finding, what's meant by existing and continuing risk. To fail to do so, the judge said, would mean any care planning would be structured without regard to the risk, leaving the subject child at risk of harm. What the judge went on to do, as we've seen, is a light on the risk arising from the mother's impulsive behaviour, and I use that as a catch-all for the broader description of behaviours which the local authority alleges, rather than the risk arising simply from one, albeit catastrophic, particular incident. And the central focus of the judge's reasoning on this was that, given all the other evidence, in particular from the local authority of those behaviours, there is no need to focus on and adjudicate one single alleged incident, because the risk flowing from impulsivity can properly be considered and assessed from everything else that we know.
Can we just look at this? I think I've got your point there, but just so I make sure I've understood it, can we just go through this sentence?
Yes.
And apply it to the facts of this case?
Yes.
And I don't want to dwell on it, and I hope not unnecessarily, but a finding, so that would be a finding that the mother had inflicted the earlier injuries. Yes.
Well, no.
Well, that's the local authority's
Yes.
proposition, isn't it?
Yes. But that makes no sense in the context of this judgment. The judge there is expressing a general principle as he discerns it.
Yes, but I know he is. But I mean,
Yes.
can't we apply that to what the local authority are asserting in this case to see what you say is the fallacy in their argument?
Yes, very well. Yes, thank you.
So the local authority's case is that a finding that the mother was responsible for the injuries to the child, to the deceased child, would be likely to identify an existing or continuing risk, which without determination could not properly be brought into the process of risk assessment. So that's their case, I think.
Yes.
So which part of that do you say is wrong? Or which part did the judge say was wrong, and did you say he was right to do so?
What the judge meant, we say by that, because of course he wasn't inputting into that sentence the words which my Lord has inputted into the sentence, or applied to this case, if I couldn't otherwise determine whether this child is at risk of future harm attributable to the reasonably foreseeable consequences of the mother's impulsive behaviour, then I would have to have some sort of adjudication about it. But in this case, as he goes on to set out relatively clearly, and I'll go through these, he says that it's not necessary to determine the truth or otherwise of one particular incident 7 years ago, because there's other evidence from which he can discern whether or not there is a risk to the child emanating from the mother's actual or likely behaviour.
A risk including death?
Yes.
Well, supposing he decides that on the evidence held to be admissible, there is no risk of death or serious injury to the surviving child.
Well, he was the trial judge. He was the judge with all of the evidence. He knew intimately that the bank of evidence. He had reminded himself that the incident in question took place when the mother was a child and 7 years beforehand. And he knew that she'd been in the assessment unit, and he knew what the assessment said about her, including the psychiatric assessment. And on that basis, he concluded that he had enough evidence to determine the question of what risk, if any, the mother posed, without determining that. And we say that is peculiarly essentially a question for the judge determining these case management questions.
Was he saying that there is evidence, leaving aside the death of the previous child, there is evidence here upon which a court could conclude that the mother's impulsivity could cause the death of the child?
Yes, not in those terms, but yes.
What evidence was he relying on? Leaving aside the death of the first child, what was the evidence which suggested that her impulsivity was such that it could cause the death of a child?
Well, can we look at the judgment? Maybe look at the judgment in order to determine what he said.
Whatever course you want. But that's
because setting out the authority's argument in paragraph 29, he then dealt with the mothers at 30. Does the authority's approach wrongly look at the outcome of the identified risk rather than the risk itself? Is the risk under consideration the impulsive behaviour, not the suggested shaking? Is any risk assessment the means and route towards managing the same, rather than the focus on preventing a further risk of, quotes,
these
shaking?
questions that he asks, are these questions that he's impliedly giving a positive answer to?
At this stage, he's summarising the case put by the mother.
Yes. Does he answer? He answer these questions in a minute?
Yes.
Okay.
And the end of that paragraph over the page, paragraph 30, concludes in this way: the mother's submission is to acknowledge that a finding of impulsivity by its nature requires risk assessment when considering the care of a young child, but that the format of the risk assessment and the resulting care planning doesn't require the clear definition of the outcome or outcomes that might follow from the same. And we take it from that what he's saying is, I needn't decide whether on one specific occasion there was one very specific outcome, because risk assessing in the present, 7 years on, and assessing, as risk assessment necessarily does, what might happen in the future, requires a broader approach to be taken. He picks up then...
Could we, before we go on, you didn't take us to the sentence that straddles the page, bottom of 273, top of 274.
Well, no, by its very nature, the outcome of the same is bound to be unpredictable and variable and a likely function of the surrounding circumstances at the time of any action, which is what then he picks up on, we say, in his analysis in the subsequent paragraphs, which is why we say that, in fact, he's widening out rather than narrowing down the risk assessment process and the range of options which risk assessors should be looking at.
The assessment of risk, put crudely, involves assessing the likelihood of something and the consequences if it does happen.
Yes.
And in this case, the consequences of something happening, on the local authorities case, was that the child would die. What other evidence is there upon which he could say that was a possible consequence if the risk eventuates?
Well, all of the evidence about his mother and her functioning, the lengthy parenting assessment, which we'll all have seen, includes negative comments and findings, the psychiatric assessment, and the knowledge that, this isn't a concession I make, but if that was the way in which the evidence came out and was accepted, that a young mother with those difficulties, including significant impulsivity, that amongst the possible outcomes, well known to these courts, is a momentary loss of control with consequences which are disproportionate to what in fact took place.
But if it's the case that this has happened before, isn't that something of particular relevance in assessing risk?
In some cases, yes, but in this is why I took the court as the judge set out, why the particular features of this case are so relevant. Why the age of the mother at the time, why the historical nature in relation to the mother's development process is so relevant in this case.
But there is a fact in this case, which is central, whatever the outcome of the proceedings and the appeal, which is that the older child died.
Yes.
And so, and did so in the care of your client.
Yes.
And so any assessment of risk is that is one of the facts on the landscape of an assessment of risk. It doesn't, on your case, and the judge's findings, need a finding to be made that your client was responsible for the death. But what is going to be of interest to the court, if it doesn't hold a fact-finding hearing, is what risks attach to your client's current behaviour in the knowledge that there has been a previous death. I mean, that doesn't involve a finding about how the death came about, but it reminds the court about the consequences of the range of risks that exist in a situation of this sort.
Well, indeed, the indisputable previous fact would give confidence and credibility to the risk assessor and or the judge when setting out the likely or the possible consequences of impulsivity or a lack of control. If it were otherwise, if that fact weren't there, there might be rather more substance in cross-examination saying how on earth can you extrapolate from the behaviours that you allege the possibility of serious injuries. But in light of that fact, that line is less open. It's a fact that the previous child died, and if it's established by the authority that the mother has ongoing difficulties, then it must be the case that an assessor would be entitled to include a broad range of possible adverse outcomes, which is exactly what the judge then goes on to set out in terms. It's the way in which he will be approaching the case.
I'm sorry, I don't follow that. I thought you said a moment ago that the death of the previous child simply had to be ignored in assessing whether the mother poses a risk to the surviving child.
Well, I've put it.
So there was only secondary importance was the way
Yeah.
you landed, where you landed on that.
Whether she poses a risk is a matter for assessment of her current circumstances. The way in which I tried to put it to my Lord Baker is this: the fact of the earlier death would surely entitle, we say they would otherwise anyway be entitled, but entitle the assessor to include a broad range of possible consequences of abusive actions.
When you told my lord that, as I noted it, death ignore entirely unless 10-day fact-finding, did you by that mean that one could view the case as if there had been no first child, broadly speaking, or that it would be out of bounds, to use a different expression, to attribute a responsibility for the death to the mother?
I meant the latter.
But then I don't see. Of course, it is a fact that the child died. We all know that, but is it a relevant fact or an irrelevant fact? I think you're saying it's an irrelevant fact, except insofar as it might have an effect on your client qua victim, so that if she suffers from PTSD, say, that doesn't infringe. It doesn't infringe any principle established by Re-H and Re-B to take that into account. But otherwise, I thought you said it's simply irrelevant.
Well, Lord, the focus in welfare decisions in Part 4 proceedings is very much to look at the wider canvas as it's described. I'm not sure any significant fact is irrelevant, to use that term, but yes, we say that if there is no fact-finding, there cannot be any assessment of risk in any way reliant on the possibility of the mothers having been responsible for the death. Well, paragraph 32 then goes on to set out or to record why it is that that poor impulse control rather than malicious act is the basis on which the authority has been putting its case, and the judge recognising that on such evidence as he had seen, and that included, of course, the inquest transcript, strong grounds for holding that any fact-finding, one could assume in that, insert into that, brackets, if facts were to be found, would recognise the event as being one of temporary loss of control. And of course, temporary or momentary loss of control are terms very often used by judges when describing what is likely to have been the motivation underlying actions such as that alleged.
Did you say one should read the words "if found" after any finding?
Well, any
That
finding,
sentence?
yeah, any finding in this case would likely recognise the event as being one of temporary loss of control. That isn't to say that it's likely that there would be a finding, and that's what it would be, but simply.
Well, and that's you did say when you read it out first time, if found.
Yes.
You invited us to read that in.
Yes.
Is that right?
Well, I'm not sure what else it could mean.
Any finding? a finding in this case.
Yes, but it isn't to be taken as meaning that there would be a finding. Simply that what the judge is exploring is what he explored with Mr. Archer, which is how do you put your case, and if the court is to make a finding of an abusive act, what's the nature of that act? And the judge there says it's unlikely, effectively, to be higher than temporary loss of control.
Isn't the judge there making the assumption which he proceeds to elucidate at 34? He's assuming there will be a finding.
Well, no, that's not how we read this at all. We read this whole passage as really being an expansion of the part of the transcript to which I took the court. So the judge explored with Mr. Archer how the authority put his case and talked about taking the case to its highest. And what he's doing here, we say, is considering at its highest what the finding of the court would be if it made a finding, in order then to consider, do I need then to go on to have a fact-finding hearing to determine the truth or otherwise of that allegation? Because without doing that, without considering what the finding at its likely highest would be, the judge couldn't properly engage with the central question, which is relevance and necessity of the process of making the finding. So when he says, I proceed to paragraph 33, on the basis that the finding were made, but within a likely context of loss of control, we say he's not. He couldn't possibly be saying, on the scant evidence I've got and my brief reading of experts, I conclude it's more likely than not that there would be a finding made, but simply that I proceed to determine whether it's necessary that this is the finding, and that's what it would be. Well, we say that then makes paragraph 34 make sense. Proceed on the assumption, not in the case generally, but proceed in this exercise of applying the Oxfordshire factors, proceeding on the assumption that it would make a case out, but subject to the caveats above in relation to momentary loss of control. And then ask myself, what impact would that have on care planning and risk assessment? And that's the point at which he says, I've struggled to identify why the care planning and risk assessment will materially change as a result of this finding being made, which is the central question. In fact, it's the answer that my Lord Bean gave to Mr. Toomey in relation to the question. It's the central Oxfordshire question. Does the finding that might be made, but which is disputed, is it one that would quite materially change the planning and risk assessment? And if it would, then that's likely to be determinative of the Oxfordshire question. And if it wouldn't, then the other factors are in play, and it's unlikely to be proportionate to undertake the inquiry. And then paragraph 35 builds on that, because the question is one of necessity. I accept, he says, and we agree with this, that for those working with the mother in the future, an answer to questions of this sort are bound to be helpful. Of course they would. Other things being equal, if there could be answers to these questions that in particular generated instantly, then of course it would be helpful. But that's not the question. The question is one of necessity. By definition, he says, quite rightly, such a conclusion will provide a court-based determination on balance of probability. And this court and others have defined necessity in the family context several times. I don't understand, he says, why those working in such a setting would be unable to bring into their care and safety planning the prospect of a range of risk outcomes, including that which would be the subject to fact-finding. So absent the convoluted, expensive, long-running fact-finding process, there's no reason why, when assessing risk, those looking at possible risk outcomes couldn't include among the range of possible outcomes, as my Lord put it, death or serious injury caused by shaking. So we say this paragraph, it goes on that I agree with those acting for the mother, that the risk planning is focused on what it is that causes risk, here impulsivity, the question of how that might play out shouldn't be limited only to those outcomes that have been established to have previously arisen as a result. Anything else would be short-sighted in the extreme, and this picks up on the point earlier.
So it does include the possibility of death as a...
Yes,
That's
yes.
right.
But
Of course,
sorry, what I was going to say, what he was saying was focusing on the one incident and only on the possibility of shaking is too narrow an approach. In fact, the risk posed by the mother, if this impulsivity is established, is broader than that, because by its very nature, impulsivity, the loss of control can play out in many different ways, and we see how they differ with differing ages of children and differing circumstances. And so, as his last sentence says, risk planning will be able to have regard to risks including loss of control and conduct towards the child, including by shaking, without such a finding being made.
Yeah.
So this is broadening out.
Part of the planning process, to use his phrase, working with the mother in the future, doesn't it? It involves discussing with the mother, planning with the mother, assessing risk in conversation with the mother.
Yes.
Because a crucial part of any control of impulsivity has got to come from within the mother herself.
Yes.
Doesn't that require a degree of insight into risk and understanding of exactly an acceptance of what the scope of the risks might be?
Well, it might well do, but it doesn't necessarily involve a fact-finding into one particular incident. And those questions, which are wholly appropriate, of course, are, we would say, appropriate to be asked by the assessors and by the trial judge hearing the trial, rather than in advance as a reason for making this decision. And in paragraph 36, he then goes on to test his theory effectively, that you don't need a finding on a specific incident years ago in order to assess risk, because the current assessment has been able to conclude without that issue being determined. We note that the final assessment has the word interim on the front, but that's clearly a typographical error. It's a final assessment. And we also note, and the court would have picked up on this fact, that at the meeting on the 17th of April at the unit, the care plan of the professionals was for the mother and the child to return unified to a domestic context. So the assessment ran its course. That assessment included, of course, a degree of risk assessment, informed both by the residential assessment over by then, 4 or 5 months, and by an extremely experienced and well-known psychiatrist injecting her expertise into the equation. And the professional conclusion at that 17th of April meeting was not that this was far too risky or we can't decide anything until the court's told us whether or not this question is going to be litigated. It was the mother can return to a domestic setting with proper support and monitoring with the child. And then it was after that, in circumstances which I'll take you to the reference, but aren't perhaps factually clear, but allegations that there was a degree of dysregulated behaviour.
Could we look at the document about this? It's supplemental bundle 322, 326 electronic.
What you're saying, this is the
It's the social worker writing to the mother to explain why the outcomes meeting on the 17th, which was returned home with a robust support plan in place, was now being changed
yes,
to, as you described it, to a mother and baby foster placement. And in the middle of the first page, we get the reason in inverted commas. Looking here at page 322, why the recommendation changed.
yes,
And essentially the social worker is trying to encourage the mother to work with that changed plan
yes,
over the course of quite a long session.
yes. The subtext presumably being a significant degree of disappointment that that which she most wanted then was removed from from coming to pass.
The report referred to section 21.7.1 is of a supplemental report from Orchards or the main report from Orchards?
The main report.
Okay. So that is at 257, 258, is it?
Well, that paragraph is at page 296.
Thank you.
And so what is alleged is the last two sentences there. Since observing mother's erratic presentation and emotional dysregulation, I've had to reconsider whether the proposed safety measures are sufficient to safeguard the child.
Is that a reference back to descriptions of mother's behaviour earlier in the report?
It is picked up on, yes. But of course, so the relevance of this, we say, are first of all, that as at the 17th of April, the unit and the professionals and social services consider themselves on the ground to be able to assess risk such that they could recommend a return home. And point two, which is also crucial, we say, although factually it may be in dispute, it's matters arising at the time, matters relating to the mother's then presentation and then parenting, which impact on the appropriate placement for the child, not factors which may or may not have happened 7 years beforehand. And the reason I'm referring each time I mention this to there being a degree of factual dispute, you'll find at page 309, paragraph 1.3, so this is the social worker's statement. The authority notes there are discrepancies between information that's in the assessment and what has been shared in the daily logs, namely the mother's emotional regulation, engagement with professionals, and the negativity impacting on her care of the child.
Sorry, is that saying that there was nothing in the logs to
Yes.
support this?
So put bluntly, the logs paint a completely different picture to that description you see both in the and then as being the justification for the shift in care plan. That's an evidential matter for the judge to consider at the appropriate moment. But the relevance, we say, is that having been told that, the local authority changed its plan appropriately, and also appropriately, I'm not sure whether it's taken place, determined it would interrogate whether or not the conclusions were justified by what in fact was observed on the ground. But this, we say, is exactly, it may have been done incorrectly, we don't know, that's a matter for the judge. This is exactly the sort of assessment of the current circumstances based on knowledge that there are many and varied risks emanating from dysregulated or impulsive behaviour, which might impact on the child. So if the mother's presentation or the assessment of risk currently suggests a different approach, that can be taken, but that doesn't have to be dependent on, and in this case wasn't, and the professionals were able in this case to make the decision without it being dependent on interrogating exactly what happened 7 years ago. So that's the question the judge asked himself, and of course, going back to where I started, if this court's asking itself, was this judge wrong, is this decision wrong, the judge had before him this evidence that a local authority, taking the case seriously with social workers, with the unit, with the psychiatrist, with the multidisciplinary risk assessments, was able to make the decision and then able to countermand the decision when it looked as though circumstances suggested that that was necessary. And that then takes us to paragraph 37 of the judgment, page 276. To the crux of the judge's reasoning, which is assessment of the current risk and planning to mitigate it, is bound to be focused on and assisted by the existing evidence of current care, informed by other available expert evidence, available network support, and other present matters than it would be by the circumstances pertaining at the time of the earlier child's death.
You mean more focused on unassisted?
Yes, there's
There's just a missing word
a
there.
missing word, yes. And it comes to this, we say, because whilst it's said now that I was anticipating a question.
No.
No.
I was just. I'm sorry.
Yeah.
I was just trying to work out what the inclusion of the word "more" in that sentence would add to it. But that's not your problem, Mr. Tyler. That's mine.
Well, I think the comparison word "than" doesn't make sense without another word to justify what it's being compared to. But this, we say, demonstrates ultimately why the fact-finding process isn't necessary. Because if one fast forwards 12 months and £1 million and a year of the mother being in a mother and baby foster unit and all the attendant pressures to the conclusion of a fact-finding hearing, and if that fact-finding hearing said, yes, I, the judge, find that the mother was responsible for the collapse of her earlier child, and no, I can't say it was more than a momentary loss of control in a 16-year-old with difficulties, then what would be the consequence of that? The consequence would be assessment of the current circumstances to see whether that sort of behaviour is likely to manifest itself. It wouldn't be removal. By then there'd be, 18 months of data in relation to the mother. But ultimately, we say it wouldn't put the court in a markedly different position to that in which it is now.
But it would involve assessing the mother's insight into an understanding of the circumstances which had led to the death of the child,
Well,
the extent to which she recognised and accepted what had happened and had demonstrated sufficient understanding and maturation, a word which is used elsewhere,
yes, it might do.
to assist with the evaluation of current risk.
It might do. So that's another 4-month assessment. And assuming, and obviously this is all hypothetical, but if those findings were made and assuming that, as in most cases, there isn't a sudden acceptance of culpability in relation to an act which is very difficult to accept, then perhaps they'd be looking for given to resolutions type process. And by the end of it, there'll be a child who's 2 years old, never left his mother's care, her mother's care. And what then? Removal, we say, very unlikely, given where the process would have got to. But the judge was well equipped, would have been well equipped, will be well equipped to determine the principal question of the risk to this child, the likely parenting to be given to this child by the vast array of evidence that he has already, going back years and years, but in particular the very, very close focus on what's been happening for the last 6 months by the time of the final hearing, whatever it'll be, 7, 8, 9, 10 months, without being unable to make a decision, absent that finding, and not least because the professionals on the ground were entirely able to do so. There's no suggestion in April, no suggestion when that decision was changed, that those decisions couldn't be made. They were made, the plan was put in place, and you know, because we've got it in the social work statement, that there's still a very close eye being kept on this. The process is going slower, no doubt, than the mother would like, but it's a step-down placement rather than anything else, and it won't step down further unless and until there's sufficient progress seen and professionals are sufficiently reassured in relation to presentation, parenting, maturation, etc., for that to be appropriate. So it's a case in which the child, her welfare, her safety are absolutely front and centre of a vast raft of professionals' vision under, at the moment, judicial oversight. And in that knowledge, we come back then to the central question where we started almost. How can it be proportionate at this stage to undertake a process which will necessarily involve a huge delay for the child, and we know even without Section 1.2 of the Children Act that is to be taken as being detrimental to the child, and with all the other disadvantages of it. We recognise, and I think the answer that my Lord Justice Bean suggested to Mr. Toomey, to Lord Justice Jackson's question, which is, are you saying it's always necessary to adjudicate on a child's death, was yes, if the outcome of the fact-finding hearing is materially to affect what is to happen to the surviving child. And we don't disassociate ourselves from that. Of course, maybe there's a degree of circularity, because that is essentially the central question in the Oxfordshire, the stellar question in the Oxfordshire list is, does this need to be adjudicated in order to determine what should happen for the surviving child? We acknowledge that if the judge was wrong about that, if the outcome would materially affect what is to happen to the surviving child, then that would be a matter for this court's intervention, at least if the judge was wrong to conclude that it wouldn't, turning it round slightly. But we say, for all the reasons given, not least the vast raft of other evidence, and the fact that the court would be far more interested in what's happening now than what happened in the very, very different circumstances of a child 7 years ago. In light of all of those factors, the outcome is not likely to be materially affected by that determination. It'll be materially affected if the mother ceases to engage, or if other current risk factors come to the fore, or if, I don't know, other mental health problems or substance abuse difficulties arise, for sure. But it wouldn't be materially affected, we say, by the answer to that question, what exactly happened 7 years ago. And we say, first of all, the judge was right to conclude that, but secondly, he was certainly not wrong to conclude that. This is exactly the sort of nuanced decision preeminently appropriate for those who've case managed a case throughout, who've shown quite such a degree of interest and grasp of the case as this judge has. And so it falls into that category of cases, going back to the HDH question of my Lord Justice Jackson, with which this court shouldn't interfere. It may be that, given the centrality of the question I've identified, which I suppose everybody in this room has identified through the course of the morning, which is, would the outcome materially affect the result, that other factors fall away slightly. I would just alight on one or two of those necessarily briefly. The first, this has already been mentioned, you've seen from the Barnsley case, Mr. Justice Mostyn estimates the likely cost of proceedings such as were contemplated before him. The public cost would be vast. In terms of court time, the impact of listing these huge cases is vast. The overriding objective to which every judge must have regard when conducting an exercise like this requires a thought to be given to the allocation of scarce resources. If I'm wrong about the central question, if determining what happened 7 years ago is clearly going to make a significant material difference, then these factors fall away. But once it's established or accepted that the judge was entitled to say, I can determine this case without that, and this judge, we know from the judgment, was going to determine the case with reference to accepting a wide range of risks, including risks of potentially catastrophic consequences, flowing from the sort of behaviours which were alleged against the mother. And assuming the judge was right or entitled to reach that conclusion, then these other factors, we say, come into play in demonstrating why he was right then to decline to case manage the adjudication of that central fact. We also point to the likely impact on the mother of adjudicating the question. Not just because she's my client and the mother, but because she is currently the carer of the child, and if it can safely be achieved, it is in this child's interests to be cared for by her mother. You'll have seen that this is a factor that Mr. Mostyn thought significant in the Barnsley case. He set out what I need scarcely remind this court of, the toll, the emotional toll on a young mother, given the history, given the fact that the inquest followed a police investigation, the inquest followed so late after the death, then of being thrown into another year of proceedings, having to relive this and facing the potential findings can't be underestimated in a way which we said the judge was entitled to take account of, because it would impact both on the child directly but also on the prospects of the child being cared for by this mother. Mullers, may I turn my back?
Yes, of course.
Just one question, if I may.
Mullers, are there any particular matters with which I can assist?
Just one, if I may. You didn't touch on the heading of the evidential result, and I'm not sure the extent to which the judge did either. It's at paragraph 25 of the judgment. But, I think my understanding of the evidential result was something to do with the quality of the product of a fact-finding, of what one might expect from it. That must at least be one aspect of what the evidential result is. Now, you haven't got a respondent's notice here, but questions have been asked, submissions have been made about finding out how and why the older child died. One of the things the judge was, it seems to me, entitled to consider is knowing what the evidence is about that, knowing what the mother's response has consistently been to that, is to contemplate what illumination is likely to result from a very long hearing 8 years after the event. That doesn't seem to have formed a part of the reasoning, does it?
Well, no.
It doesn't seem to have been urged one way or the other on the appeal, but I'm just interested in it because if one was not just thinking about it as being a question of I make a finding against the mother or I don't make a finding against the mother, but actually use it for the purpose for Mr. Toomey suggested, which was to try and understand what happened, one way or the other. I suppose the judge might have looked into what the likely chances of this being a very productive exercise are.
Well, there are, I suppose, two parts to that. If a finding were made, it could only be in relatively imprecise terms. Picking up on Mrs. Baker's question about insight, etc., it's probably fair to assume that little, if anything, would subsequently come out to shed real light on why what happened. The second part, of course, is this. There's reference to truth and whether X deceased or living person needs to know the truth. The truth isn't what emanates from a hearing like this. If finding isn't made because unknown cause is a real possibility, whilst in re-B terms, that might mean something. It doesn't mean anything in terms of assisting those left behind to understand why something happened. And it seems relatively unlikely, whatever the result, especially if it was one based on the product of balancing probabilities rather than anything approaching certainty, which, given the medical evidence, seems likely in this case. It seems relatively unlikely that the legal result is going to provide much by way of assistance either to lay family members or to those assessing exactly why what happened, if something happened.
Thank you.
I see I said something about evidential result in HW, paragraph 28. But maybe we don't need to go there. Your point is that. Well, what is your point?
Well, your point, if I may say so, was what led to the judge not wanting to embark on.
I did say there's no need for further guidance following my lords, and then I gave some, didn't I?
Yes. A mini trial is discouraged.
Is that where the phrase "mini trial" comes
yes,
from?
Yes, and the judge picked up on that at the outset, and then which way he was eager not to embark on the so-called mini trial, but didn't think he was offending against that to interrogate the local authority's assessment of its case at its highest. But of course, and this is evident from the submissions made in writing and orally by Ms. Grief, who represented the mother at first instance. The judge was taken in some detail to the difficulties in the evidence, to the fact that this is not in any way classically a so-called triad case, and then of course the added complications inherent in the Professor Mangum issue.
Yes.
And I don't know whether my lords have had a chance to see that part of the transcript.
Where is that?
So it's page 223.
The small bundle.
Oh, cool.
223.
So from the middle of the page downwards, you see Miss Grief addressing the difficulties caused by Professor Mangum's stance and setting out what was said about him in the Hammersmith case, and making the point that he's the only expert, I think it's at this page, perhaps later, in the country who undertakes this work. So if there were a need, given his refusal to be a Part 25 expert, and possibly a degree of having been discredited, to find another expert, it might involve crossing the Atlantic and using Mr. Professor McCarthy's services. And of course, the point made by Ms. Grief here and elsewhere was that in this particular case, Professor Mangum's evidence had a significant role in changing or firming up the views of the other experts. So if and to the extent that either that can't be verified or it's otherwise discredited, it rather complicates rather than simplifies the fact that there have been, as my lord pointed out, previous proceedings considering this, viz. The inquest. So whether that's an evidential result point or not, it's not a straightforward.
It's a complication.
It's complicated, and as we know, a finding or a non-finding based, for example, on expert disagreement or based simply on the possibility of unknown cause doesn't. It assists in terms, in re-B terms, that risk assessment can't be done on the basis that X parent has done Y thing, but it doesn't assist in terms of anything rather more definite than that.
No, thank you. No, thank you. Thank you very much, Mr. Tyler. Mr. Barnes?
Lord Mayor, just a couple of factual corrections. The injuries sustained by the deceased child included not just retinal hemorrhaging to the right eye, but hemorrhaging to both optic nerves. And there was hemorrhaging in the cervical spine nerve roots and ganglia. The meeting on the 17th of April did not reach a conclusion. It was no part of the local authorities' plan to proceed as things were set out in that meeting, as the note or the email at 322 makes clear. So it was not a concluded plan. Just briefly then, in reply to some of the submissions made on behalf of the respondent, when asked about the relevance, if any, of the previous issues with the deceased child, it said that they are of secondary relevance. And the reason for that includes not just her mental health now, but also her attitude. In other words, the court will be invited by the mother to consider that her attitude is based upon a situation where she is without blame, flowing from something dreadful that clearly happened. The court will be invited to make certain, take a view of the mother's case in relation to that. So the genesis of her, whatever mental health condition she says, is linked to that issue, and her attitude and the reasonableness of her attitude now flow from what she says took place in 2018. And so in our submission, she is seeking, therefore, in those submissions, to rely upon what happened in 2018, albeit of secondary relevance. She would say that the issue in 2018 is relevant, and yet she does not ask the court, or she asks the court to not undertake a fact-finding inquiry into it. The discussion in relation to the impulsive act that came up in the course of oral submissions, can I ask the court in due course to consider firstly the written case put on behalf of the local authority, and in particular submissions that appear at 159 in the core bundle, where the local authority's case is set out in detail, both as to the degree of risk, the nature of the risk, and the need, therefore, for assessment. And in the submissions at 208, where Mr. Archer is developing his oral submissions, which had closed at the point of the reference to the that the mother draws attention to, at the bottom of 215. But earlier in submissions at 208, Mr. Archer is developing the local authority's case again in relation to the nature of the risk, the degree of the risk, and in particular that the risk relating from the death provides a context. And it's only in that context where, when that issue has been determined, that the court can undertake a meaningful and full assessment of the mother's capacity to offer safe care to her child. So he had concluded his oral submissions, and we see that at the top of page 214, my lord, those are my submissions. There's then the exchange with the learned judge, and in particular the exchange at the bottom of 215, and one can see that he was developing his submission when there was not so much a stage whisper as a direct response from counsel for the mother, and he is thereafter diverted. But what he was saying at the bottom of 215, one can see, is his submissions as to the vulnerabilities which the mother had and continues to have, which brings one really to the point about impulsivity. Impulsivity means no more than a lack of planning. what really matters is not whether one is impulsive or not, but why one is impulsive. And the local authority were drawing attention to all the very many vulnerabilities of this mother, which appeared to be relevant to the question for the court to determine, if she has caused the injuries and death, why she had done so. And so in our submission, the reference to moment of madness has to be seen in that context. And it was never at any point the local authority's case that there was a loss of control. Impulsive act is what is said. And as I say, impulsive act depends upon the matters that lie behind it. And the local authority were at pains in their written and oral submissions to identify the many vulnerabilities in this mother that they said had to be considered at the appropriate fact-finding hearing. The only other matters relate to the question Lord Justice Peter Jackson just asked at the conclusion of the mother's submissions about the illumination that might be provided by the mother's evidence. In our submission, the starting point should be that of Lord Justice Baker in HW, which is that it's unlikely to be a powerful factor. But of course, in this case, what one didn't have was a written response to the threshold criteria. What one does have, however, are submissions made on the mother's behalf about the risks provided by impulsivity, but also the court might consider in oral submissions Mother's Counsel, and this appears at 233 in the exchanges, discussing with the learned judge the question of a panicked 16-year-old in a darkened room, seeing a child she believes to be lifeless, and the actions that ensued that might well then explain that which is said to exist. I say that guardedly, but in the written submissions on behalf of the mother, she identifies at 196 in the main bundle a clear account of the mother's panicked actions when she discovered the child. There is nothing to establish that any forces applied were significant and not within the parameters of such panicked actions. So there is not just the potential for the ambulance, but there's the potential for a panicked response being raised on her behalf, none of which was in a written form, as it were, signed directly.
Was that put in the course of the inquest evidence?
No.
Well, before Mr. J.M. Owen were to report as an expert in this case, there would have to be a statement.
Yes.
Obviously.
Yes. But in our submission, without that vital piece of evidence, then it would have been impermissible for the judge to have considered or applied any great weight to the question, what illumination would her account have given? Unless, I guess this, my lords, further, those are submissions in reply.
Thank you very much.
Lord, I have
Thank you.
nothing to add.
Yeah.
I'm most obliged.
In the nicest possible way. Very glad to hear it. Thank you. Right, we're very grateful to all of you. We'll reserve judgment and give our decision as soon as we can. We can't give any undertakings as to date. I take it that after the hearing originally scheduled for last week was vacated, and at the moment there is no particular date in the diary.
I think that's right. Yes, I'm grateful, my lord. The court will fix a date once judgment's been received from this court.
Very well. And we counsel know what I have to say next. We send out the judgment in draft, two things about that. First of all, we send it out not for re-argument, but for correction of typos and any obvious factual errors like dates and so forth. And the contents may be revealed to the parties, including in particular the mother and those within the mother, the children's guardian, and those within the local authority who need to know, but are otherwise confidential until the judgment is formally handed down and published, and there will be no handing down hearing as in the old days. Thank you all very much, both those of you who made oral submissions and those of you who contributed to the written submissions. We're very grateful.
All right.